There's been major changes with personal injury since March 23, 2023. It's a new tort reform that you need to know. There's been major changes. One of the big changes is comparative negligence to a modified comparative negligence, which means that plaintiffs, if you're found more than 51% at fault or 50% at fault for an accident, you recover zero recovery. Before, if you were found to be 50% at fault, you can still collect 50% recovery. The reason why this is important, because you may know that you're not at fault. You may know that somebody merged into your lane. You may know that somebody ran a red light and it's not your fault, but it's a he said, she said situation. And if the jury finds you 50% at fault, you get zero recovery. Under the previous system, if you are 90% at fault, you can still recover 10% of your damages and your injuries. Logically, this would make sense. However, the main problem with this is that now, if you're injured, you know you're not at fault. Most attorneys may not take the case because if it's borderlining a merge accident, borderlining a red light accident, borderlining a stop sign accident, that you know you're not at fault and it's a he said, she said, many times an attorney may not pick up the case because of the 50% rule. The next thing is statute of limitations. Statute of limitations is when you can bring a lawsuit against somebody. It has been reduced in Florida from 4 years to 2 years. However, this aligns with most states and encourages early filing of lawsuits. However, the shorter timelines may pose challenges for victims with long-term injuries. Another major change is attorney-client privilege, as it relates to medical referrals, has been removed. If an attorney refers a client to a medical provider, the details of that referral and any financial relationship between the law firm and the provider are now admissible in court. The reason why this is important, because a lot of people involved in car accidents or any accidents and they have no idea where to go. They go to their primary care doctors and they find out their primary care doctors do not do auto accidents. They call their insurance, their health insurance, and they find out that nobody does auto accidents. They're left with no choices, because the reason why regular health insurance providers do not do personal injury or car accidents is because they do not want to be wrapped up into litigation, wrapped up into court, and wrapped up into going to trial. So many of them do not do it. So it makes it difficult for a client to seek help from a doctor. And if you go to the doctor and you use your health insurance, the health insurance payment will have to be reimbursed back by the settlement. And the health insurance providers, most of the time, will not do personal injury cases because of the red tape of going to trial. Basically, this will limit justice and access to the injured party. Medical bills are a big change with the new law. For plaintiffs, injured people without health insurance, the defense, the at-fault party's insurance company, and their attorney will show that you should get paid 120% of what Medicare reimbursement rate is for that service. And if you don't have the Medicare rate and you're using Medicare because you're older, 170% of the Medicare rate. This is not only fair, but it's unjust. And the reason why, because most providers, not even regular health providers, health insurance providers, take Medicare or Medicaid because of the low reimbursement rate. To put in perspective, if you have a $100,000 bill and the Medicaid rate is $3,000, the defense will show $3,000 that you owe in court, but yet at the end of the day, win, lose, or draw, you still owe $100,000. And that provider will still come after you for the $100,000 owed, leaving you left holding the bag if the jury sees that the Medicaid rate applies. Future medical expenses are the same. They would be limited of what the insurance company would pay, including copays and deductibles.